There's like thousands of alleged infringements. What was Suno trained on? A big question. We now have a response. They just kind of come out and say it for what it is, and I was kind of shocked. What I would do if I was representing the music AI platforms. As a practicing lawyer, I litigate. I'm head of my litigation department for my law firm, and we're just in the weeds in regards to copyright infringement. So it's gonna influence my review of this a little bit, but I'm just like so excited. There have been answers filed by the music AI platforms, and they gave us so much more than we were expecting. As I was like reading through the answers, I was like gasping. So I'm really excited to take you guys through this because normally like these lawyerly filings, the complaint, the answers, they're pretty dry. You know what I'm saying? We learn a lot. They're super interesting and all that. But in any case, I found there to be a lot more colorful language. So anyway, where I would like to start with is a reminder, okay, of where we are at right now, which is, back in, what was it, June of this year, the biggest record labels in the world came together and they said, oh no, music AI platforms, oh no, you don't, and sued the pants off of them. And we went through that lawsuit. You can check it out if you want to watch that video. And there were 2 lawsuits filed, right? So one against Suno, one against Udio. But what we saw is that they're substantially the same, just filed in different federal courts because there's different jurisdictions. Okay. So we went through the complaint, and essentially what they're claiming is they're like, look, these platforms are not admitting where they got their songs from to train their AI. And we think they basically copied ours, like downloaded literal copies, gave it to the AI, trains the AI. The AI is basically now imitating. And this was an important distinction that we identified. It's not that the AI is sampling in that it's taking actual portions from the music, but what they're saying is that it's imitating. And if it's imitating, right, then we get into what we call derivative works. And so therefore, they needed to get permission. They needed to license. They owe us a whole lot of money. And oh, by the way, we're seeking statutory damages under the Copyright Act because under the Copyright Act in the United States, you can seek up to $150,000 per instance of infringement. And we went through the complaints. We're like, oh, look at this list. There's like thousands of alleged infringements. So that's where we were at. And we're just like, oh boy, I wonder what the response is going to be. We now have a response. And we're going to do this in 2 parts, okay? The first is that Suno actually put out a statement, okay? And this happened the same day that the answers were filed in both cases. And so I thought we would start with Suno's statement because they just kind of come out and say it for what it is. And I was kind of shocked, to be totally honest. So that's going to be number 1. We're going to look at what they actually said. Number 2, we're then going to go take a peek at the answer. And when we look at the answer, here are my questions, right? So it goes, do the answers have any teeth, right? Are they good answers? And I'm going to kind of go through the framework of just maybe what I would do if I was representing the music AI platforms. And, essentially basically say, how would I argue this? So with that being said, let's take a look at what Suno has to say on the matter. Okay, so this was by Mikey Schulman, the CEO of Suno. And this is what he had to say. Suno's mission is to make it possible for everyone to make music. We imagine a future where music is bigger, more valuable, more meaningful, part of people's lives, from professional musicians to inspiration for family and friends. So far, a whole lot of people, 12 million, have actually engaged with it. Okay, good stuff, good stuff. We're trying to get to what's going on with this complaint. We see this as early but promising progress. Major record labels see this vision as a threat to their business. Now, here's the thing. If I was, representing Suno or Udio, every time a company makes a public statement, we always have to kind of like go through and give a little analysis. And we're like, look, if you're going to come out and talk about the major record labels or say something about the lawsuit or whatever, we need to look at it and be like, look, are you about to defame someone? Or is there going to be slander? That's kind of what I was thinking as we were going through. It's like, okay, what are they going to say? Each and every time there's been innovation in music, from the earliest forms of recorded music to sampling, to drum machines, remixes, MP3s, streaming music, the record labels have attempted to limit progress. They've spent decades attempting to control the terms of how we create and enjoy music. And this time, is no different. You know, from a tone kind of standpoint, I like it so far, right? Because me as a musician, as an artist, he's like revving us up. He's like, it's a we, it's not us versus you. We're in this together. And the record labels are the bad guys. So it is perhaps no surprise that on June 24th, members of the Recording Industry Association of America, which represents the major record labels, filed a lawsuit against Suno, alleging that the data used in training our music generation technologies infringed on the copyrights of the major labels they represent. This lawsuit is fundamentally flawed on both the facts and the law, and is nothing more than yet another instance where they chose litigation over innovation. Okay, so now they're going to spill the tea just a little bit. All right, so he goes on. For starters, the major record labels clearly hold misconceptions about how our technology works. This is interesting, and we're gonna, when we get to the answer, we'll dive into this a little more. Suno helps people create music. It's a simple process, right? By learning styles and patterns and forms, the grammar of music. This is basically how we innovate. The record labels are trying to argue that neural networks are mere parrots, copying and repeating, when in reality, model training looks a lot more like a kid learning to write new rock songs by listening religiously to rock music. Like that kid, Suno gets better, more on the AI, basically just being like, this is the argument we've been hearing a lot, right? And so even if we've had the conversation on this channel with you guys, and, you know, for people who are still kind of against it, the argument for it is like, how is this any different? This isn't copyright infringement. Even if it trained on these popular songs, it's not stealing anything. It's basically just learning the, as he said, patterns, right? The grammar of music. Now, do you think that's a good argument here? All right, let's start the conversation. Drop a comment down below. We train our models on medium and high quality music we can find on the open internet. Okay, this is where we're getting now into it, right? So just kind of admitting anything we find on the open internet, just like Google's Gemini, Microsoft's Copilot, OpenAI's ChatGPT, even Apple's new Apple Intelligence, train their models on the open internet, because this is, you know, the record labels just couldn't say this enough in the complaints, and just being like, we believe that they're just using like public music, and we think that just means they're like literally going on Spotify, and they won't answer, right? They won't tell us, are they actually licensing the music? Where did they get it from? We think they're just stealing it. So now they're finally getting into it and saying, well, yeah, we train on the open internet. Much of the open internet indeed contains copyrighted material, and some of it is owned by the major record labels. Oh my gosh, they just admitted it. It's on the internet. We do use it. It's owned by the major record labels. So where are we going with this? But just like the kid writing their own rock songs after listening to the genre, or a teacher or a journalist reviewing existing materials to draw new insights, learning is not infringing. It never has been, and it is not now. The timing of the lawsuit, all right, this is like crazy. The timing of this lawsuit is somewhat surprising. So he goes on here, and he basically explains that he was in talks with like cutting in the major record labels into what they're doing. And he goes on to just be like, look, I don't know if this is, quote, overeager lawyers throwing their weight around, or a conscious strategy to gain leverage in our commercial discussions. We believe that this lawsuit is an unnecessary impediment to a larger and more valuable future of music. And you know what? That's been one of the arguments. It's that, you know what? Are major record labels actually concerned? Is this really copyright infringement? Or are they just working on their own AI apps and they want to crush the competition under the guise of copyright infringement, which may or may not be the case? We do not have cases right now that have been determined. All the pending cases and all the different circuits are like, the courts have not made a decision to, you know, basically in the favor of, you know, a company like a record label to be like, no, it's copy infringement if the AI trained on your stuff. And the reason why is because, you know, I think courts are reasonably a little scared about the impact, right? Because I think that if we had, for example, in this case, if the record labels win against Suno or Udio, right, and they have just, let's say, millions of dollars, awarded in a judgment, that case is going to be used for everyone else with similar types of situations. And so, I think courts may be reasonably nervous about the impact on technological advancements, which is what Suno's CEO is arguing here. He's like, we're just trying to advance technology, and as always, here are the record labels putting up a fight. So he goes on just to be like, the timing is real suspect. We were in the middle of conversations, and then all of a sudden, here they are with the lawsuit. So are they trying to just like play games and leverage to get a better deal? This is particularly the case because Suno is a new kind of musical instrument, one that enables a new kind of creative process for everyone, opens new business opportunities for the industry. Suno is designed for original music. We prize originality, both in how we build our product and in how people use it. People who use Suno are using the product to create their own original music. And then he goes on to be like, we actually have the more aggressive versions in the industry as far as like their filters. So he basically says, to the extent that maybe, AI does have the ability to replicate, right? He goes, that's not what's happening here. And we know that Udio took the same position. And they're like, no, we have like insane filters in place. There's no, imitation that is accruing. All right, so we're gonna get to the answer real quick. Let me just let him say the rest of his piece. We do this. We're trying to make it fun. We want you just to like, it's super valuable. We want everyone to shine. I like the positive message. The future is now. We're building big fan bases. We want you guys. I loved this. It's just so went to like the artist. He goes, the future is in explosion of new artists that are creating music in new ways, building fan bases, finding new reasons to smile, and getting famous. I don't know why that made me laugh. All right, so that's the official statement. All right, again, this came out concurrently with the answers that were filed by the music AI companies, which I have. Let's go through those together. So one thing I just want to say first, before I show you this, is, under the Copyright Act, okay, the Copyright Act says for you watching this, if you make music, you have certain rights automatically, okay? So those rights include the right of reproduction, meaning the ability to copy it, the right to distribute your music, okay? And these are all they're separate, right? Your ability to edit, to modify. So this is important because it comes into basically what's being claimed here in, the record labels just being like, we don't know what they used exactly, but we feel pretty certain that at least like a couple thousand of our songs have been used by these platforms. And the reason why that matters is because if copies were made, if edits were made, right? If modifications, if distribution of any kind, if any of these things happened, just in them happening is copyright infringement. And then remember what we said about statutory damages. If they're willful, meaning like someone knew what they were doing and they meant to rip you off and whatever. So if we can prove they're willful, that's how we get to that $150,000 per infringement. So that's important in the analysis. So let's take a peek at this answer. Become your own record label, which is literally if you're like, hey, I want to start a record label. Cool, I got you. Understand the entire music business. I want to set up my LLC. I want to do the marketing. It's a lot. So for example, sync licensing, for example, music marketing, it's significantly cheaper than anything you would ever get from a law firm as far as all the stuff that comes with it. And you want to make 6 figures from your music career and you want to do this for real. Like, I'm going to give you what you need. All right, so I looked at both. Okay, we're sticking with Suno. But I looked at the one for Udio and they are filed on the same day. They're substantially the same. So we're going to go through this one because we did Udio on the complaint on the last go round. So the plaintiffs here, right? So in fact, it's easier to read it this way. So buying through UMG, so Universal, Capitol, Sony, Atlantic, Rhino, right? So they go on and name all the plaintiffs. So they are suing and Suno is now responding. So a couple things I just want to kind of jump through. So Suno is an artificial intelligence powered tool for making new music. It's designed for originality. This is how people create in the real world to create hit songs that didn't and often couldn't exist. Now I'm reading this through a drafter's lens right now because I've literally been drafting in federal court for one of my copyright cases, like for 7 days straight. And one thing, at least, all I can talk about is what I do in my law firm and just like proper legal writing. We don't use conjugations, and this is like ticky-tacky, all right? Just stood out to me. I was like, wow, this is really casual. And not to say it's a bad thing, but we have a conjugation of, that didn't, that couldn't, instead of did not or could not. I was like, oh, this is interesting. Let's keep going. So it goes on just to be like, Suno just, it's like a human musician. It creates building blocks and all good stuff. Notwithstanding those fundamental freedoms, the plaintiffs in this lawsuit seek to shut Suno down. They are a collection of the largest record labels in the world, which collectively dominates the music industry. They frame their concerns about, one, copies of their recordings made in the process of developing the technology. That is, copies never heard or seen by anyone, made solely to analyze the sonic and stylistic patterns of the universe of pre-existing musical expression. So when I read that, I was like, because what we're expecting them to come back and say is this is fair use, okay? And that's what in like all these different lawsuits that are pending, is being alleged. And we're going to go through like how that works. But where they started, they're like, even if we made copies, it was just to analyze the sonic and stylistic patterns of the universe of pre-existing musical expression. So that just like super jumped out at me because, again, through the context of like if I'm rooting for Suno and I'm like drafting for them, I'm their attorney or whatever, I was like, I don't know about that sentence because it kind of just sounds like you just said there was copying, but like, so what? And the reason why I told you guys, I'm like, there's certain exclusive rights, which includes under the Copyright Act, the owner is the only one that gets to give the okay on making copies. So it's kind of like speeding, right? So I always kind of make this comparison. I'm like, copyright law is like speeding laws. If you speed, even if you didn't know you were doing it, like, and you get caught, you still get caught and you still get a ticket and you still whatever. So when I read that, I was like, oh, that's interesting. So let's just keep going. I'm like, what are you guys saying here? Are you just admitting it? But what the major record labels really don't want is competition. I'm like, okay. Now I'm on the same page because this is what I have been saying. I'm like, I think that the biggest claim that everyone has, whether you're like suing the AI companies or if the AI company is suing, like, I think the competition claims, which are totally separate from copyright, is where we go with this, where it's like, if you're doing something that is unfair, that's like monopolizing the market, this is how we can, get around the copyright issue. So I liked that, where Suno sees musicians, teachers, and everyday people using a new tool to create original music, the labels see a threat to their market share. Well, yeah, and the label said that in no uncertain terms. Suno will ultimately prevail in this litigation because of the values of copyright law. All right, good stuff. What Suno is and how it works. So they go through and they're just like, this is the technology. For example, you can prompt with things like new wave, synth pop, upbeat tempo, and it's basically just going to pump out like a whole new song. So the combination of these capabilities makes Suno an engine for effectively limitless creativity. Dutiful, and then, they go on to cite, they're like, a dutiful grandson can take his grandfather's poetry and turn it into music whose creation was previously out of reach. And they cite in the answer to a video where, I'm just seeing if I have it available for you guys. Yeah, here it is. So a super sweet story. So 85 or 87-year-old grandpa broke down crying because his grandson took his poem and made a song using Suno, so like great story. Love the story. So they go on, they're just like, this has been impactful. And I can even say like literally I've had clients who have just been like, oh my gosh, I've always wanted to be a producer. I've always wanted to be a musician, and I was able to write my dream album, so I firsthand knowledge can say that, people have been impacted by these platforms. The technology foundation of that engine of creativity is, an underlying model of how music works. The model is a type of computer program known as a neural network. It was constructed by showing the program tens of millions of instances of different kinds of recordings, from analyzing their constitutive, how do you say that? I don't have no idea how to say that. By analyzing the elements, the model derived a staggeringly complex collection of statistical insights. I can't even read what they're saying. It's a lot. Let me try again. Let's slow down. Of statistical insights about the auditory characteristics of this recording. So basically just being like, we're looking at how these work, okay? Through extensive refinement, Suno's engineers were able to provide a tool for virtually anyone to harness the power of that model in the service of generating new music. So again, we're taking a look because they're doing a big, broad overview about what it is. And I personally kind of appreciated this because most of the time with answers, this is how they look. Plaintiff filed this lawsuit. Defendants are now responding. Here it is. And it'll be like, as it relates to paragraph 1, defendants deny. As it relates to paragraph 2, defendants admit in part, but deny the remainder of the paragraph. So the fact that they actually like are going through and telling us a story, I'm like, oh, that's great. It's giving us some insight here. All right, so to be clear, the model underpinning Suno service is not a library of pre-existing content outputting a collage of samples stitched together from existing recordings. Instead, it is a vast store of information about various musical styles consisting of that are used together for new songs, basically. All right, so in the design of this product, Suno has in fact constructed a sweeping set of safeguards. All right, so this is kind of what the CEO was saying. It's like we have the absolute, most robust safeguards just to make sure that there is no sampling happening and there's none of this imitation. These really are like brand new original songs. So we want to make sure it doesn't resemble anything too much. But the way they worded this kind of stood out to me because it goes, we have these safeguards to ensure that any given output will not resemble too closely a particular recording the model was exposed to in the training process. Okay, that wording is very problematic for me because I'm like, all right, so once again, you're saying it does push out stuff that resembles the stuff it trained on. That's what the record labels are saying, right? Because the whole thing of your song sounds too much like mine. And oh, by the way, I was like your producer and I had presented you, an instrumental and you decided not to use my instrumental and you went and recreated it. That's potentially copyright infringement. So that little nexus, that little jump of like our thing is not the exact identical. That's where I'm getting lost a little bit. I'm like, who's writing this? I don't know. Let's keep going. The tool has been designed not to be able to process requests for new outputs when they are described to be reference to a particular artist's name rather than by reference to a musical style and genre, while Suno allows people to enter prompts. Basically, I think what they're getting at is that, you can't put in like, hey, give me a Snoop Dogg song. But, obviously we've seen that people are generating like look-alike songs is what we'll call them. In the ordinary course, these measures are highly effective, right? So they're filters. Plaintiffs' apparent effort to misuse the tool to generate renditions of pre-existing songs discussed further below are really problematic. So when we looked at the complaints, they had all these examples, including Mariah Carey, over and over and over. And we even saw other YouTubers. We've covered this on the channel, but other YouTubers went in and were able to get these platforms to generate these look-alike songs that sounded almost exact. Were they using the same lyrics in some instances? Yes, but that wasn't the point. The point that it was the same melodies, the point that it was the same kind of like inflections in some instances. So, what may have been, let's say, a technicality, maybe the filter wasn't quite working right that day. We don't know. Okay, but this is what these music platforms are saying. Plaintiffs' sole claim that copies used in the training process never seen or heard by anyone are infringing and why the law were ultimately precluded. So they go on to be like, record labels likely control 75% of the recordings that people listen to. I'm like, again, I wouldn't just say something like that. Like, give me something. Give me a Forbes magazine article. Someone has said something to validate this statement. You are not supporting this statement. They have filed a lawsuit contending Suno is liable for copyright infringement just for having developed its service in the first instance. No, I don't think that's the case. The relationship between many of the facts alleged in the complaint and the legal theory asserted is, however, at best attenuated, right? So it's very weak. At worst, outright confusing. The only act that plaintiffs contend was unlawful is Suno's allegedly having made a copy of copyrighted sound recordings as part of the process of training the model. Okay, so here's the thing. I think that the complaints are set up well enough where it's not just where they're like, you're imitating. There's two parts to this. There's the you must have downloaded, and I even talked to my like app developer AI guy. And I'm like, you are literally the expert on this. Tell me. And so, he briefed me on it. And he's like, yeah, we could have the AI go in and like literally stream from a platform like Spotify, but it's not the best for training AI. The absolute best way to train AI is to make copies. And so it has an opportunity to have the file itself, to train on it. And then when it doesn't need it anymore, we don't need then the file goes. So what the complaints were alleging is like step one, they copied. Remember back to the Copyright Act. They copied without permission. It's copyright infringement. But then step two, they're like, we have just thousands and thousands of instances where there's been lookalike tracks that we were able to generate. And there's just no way that this would just happen. And there would just be melodies that are exactly like the original just because of these general prompts, unless the AI had been actually trained on our music. If it did train on our music, that's copyright infringement because we didn't give you permission and you should have gotten a license and da 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 da. So again, my interpretation is a little bit different than the drafter here. Plaintiffs explicitly disavow any contention that any output ever generated by Suno has ever infringed any right that they own. While the complaint includes a variety of examples of outputs that allegedly resemble certain pre-existing songs, it goes out of its way to say that the complaint is not alleging that those outputs constitute actionable copyright infringement. Plaintiffs are not alleging that these outputs themselves infringe the copyrighted recordings. Okay, so what we did, at least I think we are all on the same page in that the record labels are not alleging sampling. I'm kind of like, but should they have? I don't know. From what I've seen, I gotta be honest, like some of these, producer tags that are kind of showing up here and there, it's a little bizarre, is all I can say. And I'm not even saying that anyone was like intentionally trying to sample or whatever, maybe there were glitches happening. I don't know. To the extent that what I have heard from music distributors is that when they're distributing AI music, that sometimes the music gets flagged by content ID. And the content ID is like, hey, we think this is this original human-made song. And so there's speculation that there is particles, fragments of the original songs that are kind of making it into the output. Now, I don't know, obviously, which platforms all the songs were made on, you know what I'm saying? Because again, we're Suno and Udio are kind of the big boys, right? So we're assuming this is the absolute best tech. But like at the end of the day, everything is a derivative work. And that is essentially what we're saying. We're like imitations, new versions, whatever. If it was inspired by, which is what, the argument is. And I'm going to be fair about this, okay? Again, if I was representing these platforms versus representing the record labels, I'm just showing you where the arguments are, not saying who's right or who's wrong. I'm just, this is how we do this. That concession will prove fatal. It's fair use. Okay, now finally, fair use, right? I'm really excited to see their analysis about this because this is, potentially how they survived this. It's fair use under copyright law to make a copy of a protected work. That is true, right? As part of a back-end technological process invisible to the public in the service of creating an ultimately non-infringing new product. All right, so I promised a quick chat about fair use. So real quick on this, it's just, why would music AI be able to claim fair use and win? Fair use, there's 4 factors we kind of go through. And what AI music companies allege is that they go, it's transformative, that even if I go and take Universal's music, okay, and I give it to my AI, it's intended for a different purpose, which is to train the technology. I'm not using it in the same kind of way where I just take your song and then I put it on music platforms and like redistribute it, which is just clear copyright infringement. So that's what transformation. The second one has to do with the harm. What these AI companies are alleging is they're like, what harm are you talking about? Just because we trained on your thing real quick, right? So the example I like to use is on this channel, I react to other people's content. It might be a music video. I might show someone's picture while I'm talking about them. And so under fair use, right, I am transforming, right, the purpose of the thing. And then also I'm not doing it in a way that's causing harm, right, to the, original copyrighted thing in the marketplace. And then we look at the nature of it. Is it informational? Is it functional? And so in this case, they're like, we're literally, if we are stealing your music, we're doing it because we are gathering information and we're training. We're not doing it because we're going to like replicate it or sample from it. So for that reason, the third part, which is like the nature of the use, we win on that too. And then they go on, and the fourth one is, how much of the thing did they use? And I thought this one was interesting because they go, again, just for training purposes, we're only using the absolute least amount possible. And Tim, my expert on music AI stuff, he's like, in fact, we use it temporarily, and then the file gets discarded. The AI doesn't need it anymore. So that's what these music AI and really just AI platforms in general, their argument for fair use is based in all of that. It's fair use because we are not basically using it for anything other than to actually train the AI. All right, so moving on, every single time the question has been presented over and over, basically the fair use argument has been successful. And so they cite to a bunch of cases, and obviously we know that all the AI cases right now, everything's pending, right? There's tons of lawsuits over the same issue of you accessed my pictures, you accessed my paintings, you accessed my music, you didn't get permission, and now I'm suing you. And the defense is fair use. Why plaintiffs can contend the outputs are infringing. All right, I gotta make a note about this because they go, let there be no doubt. The outputs here are a rule, non-infringers. The copyrighted statute speaks to this issue with clarity. So they quote this, and they quote this, and they go down to show you. So it's from 17 USC section 114B. In section 114, that's where the Copyright Act delineates those rights we talked about, where the right of reproduction, distribution, modification, public performance, all this stuff. That's where it says. So little b talks about the ability to reproduce. And this is where, again, when I was reading this, I was like, what? So this is what they say. They go, well, pursuant to little b, if you guys remember, the very famous, Taylor Swift, she's re-recording her old albums, even though someone else owns the rights in the originals. And it's because under the Copyright Act, section 114. And I'm like, I don't think that's right. I'm pretty sure that it's not correct. My understanding, and this is how it works, right? So major record labels, they sign artists like Taylor Swift. And when they sign them to deals, they go, hey, we own your music. We're going to pay you a certain amount of money. You're going to get a certain amount of royalties. And there's always a provision that has to do with re-recording. Now, before the Taylor Swift started to re-record her stuff, industry standard on re-recording was about 5 years. So meaning you're an artist, you get signed, they do the stuff, and they go, at the end of your agreement, we are telling you, you cannot re-record your music for at least 5 years. And then what happened is that Taylor Swift, enough time went by, and then she got all, upset about all her situation, and she went and re-recorded her music, and now she's, they're doing great and making good money and all that stuff. And so what major record labels did in response to this, including Universal, is they extended that period that the artist has to agree not to re-record. So, now it's more like 7 years, and it's even more aggressive in some cases that I've seen. So I mentioned that because I'm pretty sure that was the situation for Taylor Swift. So I'm just like, as I'm going through this, I'm like, I couldn't be mistaken. That was just my understanding. Okay. So anyway, they just go in and they're basically like, it's okay for Suno to imitate or simulate plaintiffs' recordings. And this is where they're losing me, because I just go, this is not how I would have argued this, because I feel like you're giving ammunition to the record labels to be like, see, they're literally admitting it. Like, they disregard the Copyright Act. They're just saying they are imitating or simulating. But even that kind of conflicts, because just earlier they're like, that's not what we're doing. So they just go through more analysis, and they start getting into basically talking about the beginning of the copyright, and how copyright has progressed, and just giving a whole lot of great backstory that we're just going to skip through. So right here it goes, what was Suno trained on? The big question. It's no secret that tens of millions of recordings that Suno's model was trained on presumably included recordings whose rights are owned by plaintiffs in this case. All right, so all the news outlets that I've been reading, everyone's going wild on that admission. They're like, yeah, they just said it. They're like, yeah, we did it. So there it is. Let's see what else they say. As paragraph 9 of the complaint itself recognizes, an AI tool designed to generate new instances of creative expression in long-established artistic genres must, in its training phase, have encountered and identified common patterns from prior examples, essentially as many as can be located, many of which plaintiffs control. So they're like, yeah, we did it. And we obviously, to the extent that we read the CEO statements as well, I dig them just kind of owning it, because look, if this is where it was going anyway, they're taking ownership of it. which I think is smart because they're going to get into discovery, the discovery phase after you file a complaint and then there's answer or, some responsive pleading. You go into discovery. And during discovery, you get to ask a bunch of stuff. And the other side has to give it to you if it's relevant to the case. And so, they probably saw that was coming. And they're like, we're going to have to disclose what we licensed or didn't license. And so, you know what? Let's just come out with it. Now, obviously, that's what the record labels are claiming. They're like, this is a disaster. And, they've been hiding this and it's all the shady conduct by these music AI platforms. But in their defense, what they're saying is they're like, yeah, we did it, but we're not saying that we were trying to hide anything. A, it's kind of like none of your business. But B, now that you're suing us to try to get a market advantage, which is what they're saying, they're like labels, you're just trying to shut us down so you can go do your own thing or whatever. Yeah, now we're telling you basically how we've been doing it. Let's see. These similarities, plaintiff contends, are only possible because Suno copied copyrighted recordings that contain these musical elements. But that conclusion actually does not follow from the investigation that supposedly preceded it. In fact, even a cursory search on Spotify reveals literally hundreds of different recordings of Johnny B. Good. All right, so in this prior analysis, basically they cite to the complaint and they're like, they say, in the Johnny B. Good, they prompted it and they only told it to do 1950s rock and roll, rhythm and blues, 12-bar blues. So they just had, this little description. And they go, what it generated with the appropriate lyrics was this song, Johnny B. Good. So then the drafter goes on to say, in fact, if you search Spotify, you can literally find hundreds of Johnny B. Good recordings. So basically saying cover songs. Are you guys following me? So they're losing me again here because they're like, well, even if we did it, whatever, because there's cover songs on Spotify. And just under the Copyright Act, cover songs are permissible. And, the government encourages that. It's like, yeah, do your cover songs, put them on music platforms. They can only be on music platforms. And oh, by the way, digital service providers like Spotify, they're ones that are required to get the mechanical license. So actually, creators, if you want to create your own version of Johnny B. Good, you are okay to do that under the Copyright Act. And then songwriters are paid through the Mechanical Licensing Collective. So this is how it all kind of works synergistically. So people can do their own versions. And so in the argument here, just being like, well, actually, you go on, you can find all these cover songs. I'm like, you're losing me because that's not just consistent with the rights and what's being argued right now in this complaint. So they do a little bit more, analysis. So when plaintiff's lawyer prompted Suno with the lyrics to the musical composition, Johnny B. Good, oh gosh. So they go, when the lawyers for plaintiffs got Suno to generate the lookalike Johnny B. Good, right? So they could use it in their complaint as a ha-ha moment. They go in their answer. They not only flagrantly violated Suno's terms of service, which are designed to ensure the product is used to generate new artistic expression, but also apparently committed acts of infringement of those third-party publishers' rights. Again, my interpretation, maybe I'm misunderstanding what they're trying to say here, but they're just like, the lawyers went in for plaintiffs and they're like, we're going to catch you. And so we're doing this Johnny B. Good lookalike. And so they go, well, when the lawyers did that, by doing that, they infringed the publisher's rights who own the Johnny B. Good song. And I'm like, I don't think that's what you want to say. Don't you want to say that this isn't actually a lookalike? You know what I mean? So I was struggling a little bit, okay? But I'm like, all right, let's see if they can bring it home here. More importantly, however, this case is not a whodunit. Okay, I love that. To the drafter, I love the casual and colorful and kind of playful language that you use, okay? Irrespective of whether, Universal's particular version of Johnny B. Good was in Suno's training data, many Universal recordings probably were, given the massive size of the catalog, which is assembled through decades of transactions. Plaintiffs will have plenty of opportunities to comb through the relevant data, all of which has been preserved once discovery commences. And when the facts come out, this litigation, or more precisely, the portion of this litigation concerning Suno's conduct as opposed to the portion of this litigation concerning the record label's actions, will be why the law has always permitted comparable uses of copyrighted works and why this time should be no different. There's one more thing that they argue, which I actually think is interesting, and I liked seeing it here because I think it's a creative way to kind of attack this, okay? But this is where we're at. Let's just take a quick beat. So we go back through and we go, all right, so just to recap, Copyright Act, all right, exclusive rights for the owners of the song. You can't copy without authorization. So to the extent there was in fact copying, do the record labels have a claim for copyright infringement? Sounds like it, right? To the extent that there were then imitations made, which is what the record labels are arguing. They go, there was an imitation made. It was a derivative work. It was something that was based on our song, not a sample, but super close, which they kind of said in their answer. They're like, yeah, I mean, it wasn't exact. This is where we're at. So they have one more thing they're going to throw in, okay? So they go, major labels, aversion to competition. So they go, a healthy portion of the complaint is dedicated to describing plaintiffs' concern that the outputs of Suno's service will compete with their catalog and sound recordings. That's 100% what the complaint said. The record labels are like, you are literally going to drown us out and make our songs worthless. Okay, so that's true. They go on, it's going to cheapen, it's going to drown us out. And then more background. So more recently, the record labels have made a standard practice of seeking to thwart competition from smaller independent labels using complex contractual constraints to prevent streaming services from leaning more heavily on smaller labels willing to license at lower rates. Okay, if you guys want to sound off in the comments at this point, I don't have a problem with that. We talk about that on the channel all the time. We're like, hey, if you decide you ever want to sign with Universal, cool. I do these deals all the time, but just understand what they say. You're not going to own your music. You're getting a teeny tiny portion of royalties. By the way, anything that they pay for on your behalf to themselves, to their team, to whatever, you have to pay back from your earnings, which means you're not going to get paid anything, possibly ever, unless, you know, you're making a lot of money. So in the whole like Suno and Udio painting the record labels as the villain, I do think that's smart tactically. And so what they're saying here is they go on. They're like, the record labels have come in. They've tried to crush the little guy. They sign, you know, these crappy deals, and they get like lower rates. So, you know, we don't have a problem with anything that, you know, is being said at this point. Collectively and individually, the record labels wield, I love it, wield massive market power, and they have not hesitated to exploit it fundamentally anti-competitive ways. This is not speculation. These issues have been adjudicated in regulatory proceedings. Now, this is where it gets so interesting. And I definitely, you know, like props to the drafter just because I think this is a creative argument. In the AI space, the labels have been even more brazen. On information and belief, they have sought to impose deals on a broad array of licensees, effectively requiring an across-the-board no AI policy. Okay, so basically, like, they do deals and they say you cannot do anything with AI. Essentially trying to leverage their exclusive rights under copyright law to strong-arm music users into categorically avoiding AI products. With respect to music startups in the AI field, specifically, the relevant facts have not yet fully come to light. Okay, let's take a quick beat. So it's like, what are they talking about? What they're talking about is that you cannot use your copyright to create restrictions in a market. So here's an example. My law firm, we represent a lot of tech companies, okay? So if in the tech company's terms of service or terms of use, right, it says you as a user, you are buying a subscription to our product. By using it, you cannot go and develop any competing computer software product. It's not that they're saying you can't go steal our stuff. It's okay to do that. But they're specifically saying we will stop you from doing anything that is competitive. And like generally speaking, right, the federal government does not like that. That is no good. They don't like what, you know, it's called antitrust. So it's like antitrust laws. They don't want that. So that's essentially what they're arguing here, which I think is kind of creative. And another example would be like bundling. If someone is selling, you know, a bundle of a music library or films or whatever, and they go, if you want to buy the one, you have to buy them all. You cannot get the one. That actually could be problematic as well, because if you are forcing someone to do something in relation to your copyright, so that's what they're saying here. All right, so let's go on. They go, this behavior is not just atmospherically relevant to this case. Love that. It goes directly to plaintiffs' long-standing practice of misusing their aggregated copyrights to gain an unfair advantage in the marketplace, well beyond what copyright law itself allows. And then it goes into just the analysis, if there's a copyright misuse, here's the elements. It's a violation of antitrust law. The copyright owner is illegally extending its monopoly, so meaning taking over the marketplace all by itself, or that the copyright owner violated public policies underlying the Copyright Act. Okay, so then they conclude. Now, the rest of this is where they now go into what I call kind of the more boring response, where it's like, we admit in relation to Section 4, we deny, we admit, we deny. So this is generally how answers look. So all that kind of pre-roll and storytelling and telling us about the Copyright Act and all that stuff is great. I dig it. And it gives us a lot of insight into kind of how they're going about this. If I was drafting this or reviewing this or whatever, I would have taken a little bit of a different approach. I would have taken out some of the sentences that they use that I think, are going to be used against them. They may need to backpedal some of that, but this is where we're at. Okay, so going back to the original questions, we asked, does this answer have any teeth? Do we think that they're going to survive this complaint? Are they going to get just totally crushed? Or going back to really what the strongest argument is for these music AI companies of fair use, do they have a good claim under fair use? And we've talked at length why we try to beat up the claim and why it's not good and it's violating people's copyrights and all this kind of thing. But let's take their position, which is if we are just using this thing in a very limited capacity for training purposes, it's not actually using it's not sampling, right? It's creating patterns and what did the CEO call it? The AI language. It was something better than that. Does this answer have teeth? Yes. Again, some things I would have done differently. And do we think that they're going to be able to kind of move forward and be successful with this? This is going to be interesting because I don't know, man. It's echoing in my head as far as, what Suno's CEO said. He's like, we were in discussions. And then out of the blue, they sued us. And you definitely see some companies that are tactically doing things like this because let's say, they do have copyright infringement claims, right? And let's say that they have a likelihood of being successful on those claims, right? And in the millions and millions of dollars, it is an indirect way to stronghold, right? Someone else. And that's what's being claimed. What do you guys think about this? Drop your comments down below and we will continue to cover what's going on in all things Udio and Suno.